Good morning, good afternoon, everyone, from where you're joining. It's such an exciting moment to have all of you here to discuss an important topic pertaining the regulation of digital markets across the globe. And we've been holding this event on the African Competition and Consumer Protection Center, which is a YouTube channel where we have informal discussions about competition law development in Africa, in particular, and also competition law enforcement in the global south and also in the global north, and how we can share ideas and experiences for better enforcement of competition law and investment. So today, I'm super excited to host two of my friends and colleagues whom we've met in different forums. We've discussed different topics. But today we are going to discuss about the regulation of digital markets in India. So far, as we know, for those who have been following this topic, we've had a lot of attention on the EU Digital Markets Act. And therefore, today we want to discuss another region and understand how the development and the adoption of digital markets bill in India can influence Africa's regulation of digital markets. So with us, we have Dr. Amber Darr, who is a lecturer in competition law at the University of Manchester, and she's also a senior fellow at the University College London, where she also obtained her PhD from. And she's also a barrister at Lincoln's Inn and an advocate of the Supreme Court of Pakistan. And very importantly, she has authored a lot of articles, but one of important publication is a book titled Competition Law in South Asia, Policy Diffusion and Transfer, which I'm asking all of us to have a copy and read and understand how competition policy has developed in Asia. And then we have Manjushree RM, but I like referring to her as Manju. Manju is a team leader and a senior resident fellow at Vidhi Centre for Legal Policy in India, which is a think tank that advises the government of India in policy ideation and legislation drafting. And she has played a great role in competition law and development, especially in India, whereby she has previously advised the government of India on the enactment and modernization of the Indian Competition Act of 2023. And recently, she also advised the Ministry of Corporate Affairs and the Committee of Digital Competition Law in the preparation of the draft Digital Competition Bill of 2024. And as having Manju here simply means that we are going to hear the inside story of the legislative process that led to the adoption of the Digital Market Bill of India 2024. So I will start my first questions, and the first question, we are going to have a discussion with Manju and would like to understand what really informed India to adopt an ex-ante legislation in the regulation of digital markets. If you give us the history, the legislative process, the market structure of India, and what was really the driving force, who are involved, who influenced, which approaches were on the table, and why did you adopt the approach that you adopted? Thank you.
Absolutely. First of all, it's so fun. I mean, it's always fantastic to be on the same panel as Bella, and of course, Dr. Darr is. It's very in very few instances do we have learnings that we share across the global south, and this is one of those things that's just very close to my heart. So again, thank you so much, Bella, for having us here. So in terms of the digital competition bill that India has recently come out with. So let's sort of rewind a little back in terms of what is it that the Indian Competition Act does, and what was the the history behind why the Competition Act 2002 looks the way it does. So the Competition Act 2002 was enacted while the act was written in 2002. It only got enforced much later, I believe, somewhere around 2012. And Amber, please correct me if I'm wrong on this, but I think around 2012. And because this was stuck with a series of litigation on whether the CCI is an expert body really, is it equipped to do what it does? Because in India we try and follow a strict separation. We try and follow separation of powers to the best extent possible, but we saw this change really with market regulators that emerged after liberalization, which meant that you had expert bodies that were looking after markets, in a bit of a piecemeal fashion. So this meant that the SEBI as a board came about, the securities regulator came about somewhere in the, the 90s, the late 90s, 1994 to be precise, but started functioning around 1996. And similarly, the Competition Act, replaced what was the MRTP Act that we had earlier on. And post-liberalization, we felt that, we need a Competition Act really. And this Competition Act, in fact, went through a holistic review in 2018. And there was a committee on, that was the CLRC, the committee on the CLRC is the Competition Law Review Committee that was constituted in 2018 that released its recommendation on what needs to be updated in competition law in as recent as 2019. And to most of our surprise, because that's when the Furman Committee, etc., was also going around, was doing its, thinking and designing what a competition framework for digital markets could look like. And the Indian government at that point in time, endorsed by the CLRC, of course, had taken a view that, the Competition Act 2002 does not really require many changes to keep up with digital markets. And this was in 2018. 2019. Now, fast forward to 2023, 2024, we have a completely new bill in place. And, again, a caveat here, it's a draft bill. It is not even a bill that the Ministry of Corporate Affairs has put out. It's merely at a recommendation stage, and that the committee has recommended that this is what a legislative approach to a digital competition bill should look like. So whether this is the same thing that's going to be adopted by the government, whether the same thing will go through the parliamentary processes, whether there are many changes yet to happen, we're yet to find out, about a lot of this thoroughly. But yes, in these 6 years, I think there were a bunch of crucial things that happened. One, India also saw its own flurry of digital market activities in a way where 2018 and 2019 really did not put us in a spot to sort of anticipate the way digital markets would grow in the forthcoming years. And this was also sort of, I think, propelled by COVID, where, quick commerce and e-commerce became, ways for people to communicate and sort of survive on, especially in terms of getting essentials, etc. So simply the role that platforms sort of play in the lives of everyday people, I think, sort of got heightened. And this was also considerably also accompanied by a series of complaints and allegations about abuse of dominance and abuse of their bargaining power by platforms that was leveled against a lot of sellers, at the CCI level. So it was the fact that, the central role that platforms play in all our lives, I think, became fairly apparent through between 2019 and 2023, and also because of COVID. Second, a series of cases before the CCI itself, and most importantly, third, the precursor to the Committee on Digital Competition Law was in fact the Standing Committee on Finance that looked at, digital, like the level of competition in digital markets and what could really be done. And in fact, it was the Standing Committee on Finance that suggested that maybe India explore what other countries are also trying to do at this point in time in terms of, ensuring there is contestability in digital markets. So yes, and this report came out in 2022 December, and 2023 February is when the Committee on Digital Competition Law was constituted by the MCA to look at the recommendations of the Parliamentary Standing Committee on whether there is a need for an ex-ante law or not a little more closely. And fast forward to a year, we are, the report came out in March 2024, where it was a comprehensive report along with a draft digital competition bill, largely modeled around the EU's DMA that, the committee has proposed should be what, the India's approach, that should be India's approach to digital competition. And this is, again, still at a recommendatory stage. The committee, the MCA has invited public comments, and I think the MCA is at the stage of looking at public comments at this point in time to see, what could be improved in the bill and what is it that's going to stay. So yes, I think that highlights the need for discussions of this nature, because there is still a long way to go, and it is people like us that will, shape this discussion. So that's a little bit of a brief background on, what led to the digital competition bill itself. I'm happy to answer any further questions on this or move to Amber.
Yeah, so just as you continue, maybe you could also highlight for us the main features of the bill.
So, because a lot of the bill is modeled around the DMA, it's very difficult for me to talk about the draft digital competition bill without the context of the DMA at large. And this is largely because of two reasons. One, when the committee started its deliberations, the DMA, the Digital Markets Act in EU, was one of the only acts that was completely in force at that point in time when the committee started its deliberation. So in terms of an easy reference point, there was something that was guiding the committee at large. And second, a lot of Indian competition law, our jurisprudence, etc., is heavily influenced by UK and EU competition law. The TFEU and the UK Competition Act have played a very crucial role in how Indian Competition Act 2002 has been shaped, and also how enforcement practices in India, sort of get shaped. So there was a natural inclination to see what EU and UK were sort of doing in this regard. Of course, the DMCC had just about been, I think we just were at a draft stage at that point in time with the DMCC. The DMA was, however, enforced. So in terms of what are some of the crucial aspects of the bill themselves, I think they three things I think stand out about the bill. One, the thresholds themselves. The entities that sort of, fall under these thresholds are called systemically significant digital enterprises, or SSDs, which are largely equivalent to how we understand gatekeepers under the DMA. Second, there are a set of obligations and conduct that that once you become an SSD, you're expected to, follow, and this is all in the chapter on obligations. While these are largely broad principles that are there in the legislation, the nitty-gritties of how this is going to be applied to each particular platform, depending on the kind of business that they are in, is something that the CCI is going to specify, at least in terms of the current mandate of the bill itself. And third, in terms of the rest of the procedure, which I think is something that we'd like to sort of maybe spend some time thinking about, is the enforcement regime under the draft digital competition bill is transplanted from the Competition Act 2002 without many changes to it. So in terms of whether this is going to speed up investigations or the efficacy at which we are able to really pinpoint errors in the way digital markets are functioning and remedy them swiftly, I'm not sure if this is going to have the intended impact, because it seems like we're changing around the threshold at which we intervene. We're changing around the nature of obligations that we're going to impose, and that the obligations are known to you perhaps before than at the stage of when you violated that you have perhaps violated. But the process that we are going to use to figure out whether this is a violation or not is largely modeled around the Competition Act in and of itself, the Competition Act 2002. So these are the three main highlights for me about the bill, and we can sort of pick it apart in the way you see fit.
Okay, thank you so much. So I'll go straight to Dr. Darr, and I have a number of questions. And one of them is that there's been criticism against the India adopting an ex-ante regulation. And some of the criticism is that, one, there is no market failure in the Indian market, because India is the third largest country in the world with startup, and therefore the digital market bill is likely to hinder innovation. And also the quantitative and the qualitative test for the SSD is ambiguous, it's vague, it's broad, and business firms are not sure about whether they'll fall under the SSDE test. And I would like to know your opinion about this criticism and whether they are valid or not.
I'll just thank you, Vala, and just like to begin by saying how lovely it is to be here, and again, just be speaking with you. And Manju, always a pleasure to be back with you on a panel. Before I answer your very specific and important questions, Vala, I would like to just zoom out a little bit and think about any country really that thinks about adopting a law such as the Digital Competition, the Digital Markets Act that the EU has. And I think, as Manju said, the Indian Competition Bill is very much based on that law. I think a very important factor to be considered is institutional capacity. Do we have, or I shouldn't even say institutional capacity, I should simply first say capacity and then focus on specific institutions. So I think the Indian law, for instance, places a lot of responsibility on the Competition Commission of India to enforce the new bill. And I would really want to spend some time, and I can give you some insight later on, perhaps in the conversation, about how the Indian Competition Commission has fared in enforcing the primary law that it was entrusted with, which is the Competition Act of 2002. So I think that's an important question for us to consider. The second important question, of course, is do we have the relevant capacity for digital markets? Now, when we think about the DMA in the EU or we think about the DMCC in the UK, we know that a lot of time and money was invested in building capacity and in creating the sort of necessary expertise for understanding the issues relating to the digital markets. And again, I would like to just question that, have we done a similar exercise in India, or indeed any of the other countries that are engaging in this process? Are they engaging in a similar exercise as well? Thirdly, the third capacity that I think is important to consider is a judicial capacity. Because as Manju very rightly pointed out, the enforcement, sort of the infrastructure that the Act creates for its enforcement is, as you rightly, I'm just going to borrow your words, it's lifted from the Competition Act. We haven't done much to sort of really think about creating a regime that is specific to digital markets. And then my question would be, if everything is going to go to the courts, is our judicial system, or indeed the judicial system of any country that considers adopting such a law, is it really up to the mark? I mean, maybe that's not the politically correct thing to say, but is it really, does it have the capacity to understand the issues that arise from these laws? So with this in mind, I think I'm just going to go back to, a couple of your questions, Vela, is what is this Act really doing? Is it going to dampen innovation, or is it going to spur innovation? And I think there's no sort of really clear-cut answer, but I'll attempt an answer, which is that in as much as the Act focuses on SSDEs, which are systemically significant digital enterprises, quite similar to gatekeepers, Manju, as you said, under the DMA, then it's not really hampering innovation in the broader market because it's focusing on gatekeepers. What then becomes important is how we define gatekeepers. And if we are defining them too stringently, for instance, I remember one of the criterion for defining gatekeepers is user base, then are we inadvertently restricting currently smaller digital enterprises from growing? And if we're inadvertently doing that, then yes, there will be hampering of innovation. We are also straitjacketing enterprises into these sort of metrics and not letting them think out of the box to see how they can grow. And I think we know that digital scale grows exponentially compared to, say, brick and mortar scale. So really, when we say it sounds like a lot, it sounds like a big threshold when we put it on paper, but actually digital scale with network effects, it grows very, very rapidly. So I think that is perhaps a valid criticism, especially in a market like India, which is focused, which sort of prides itself rightly in viewing itself as a digital startup market rather than a market that has been under heavy abuse. I mean, we know that India has the large platforms such as Google and Amazon and Meta have penetrated the Indian market, but are they at a scale that warrants this kind of intervention from the Indian authorities or from, in fact, the legislature itself? Is a bigger question, which I don't think the report answers. So when we read the CDCL report, India loves acronyms, and I fall into that trap as well when I'm speaking about India. So this is the Committee on the Digital Competition. What is CDCL, the Digital Competition
Law? Committee on Digital.
Yes, thank you. The Committee on Digital Competition Law. I think what I would have liked to see is a market analysis that, when we are attempting to define what a systemically significant digital enterprise looks like, then who is caught by these metrics? And I don't quite have that from the report. When I see the stakeholder comments on that report, they're very roughly, again, Manju, divided according to nationalistic and anti-nationalistic lines, because you see the sort of foreign platforms such as Google saying we shouldn't have ex-ante regulation, and the local startups saying, oh, that's probably not a bad idea, let's have some ex-ante regulation. And I don't think that shows that kind of refinement in thinking or economic thinking that we would like to see going into the bill. So I think I'm just going to stop with saying that some of these criticisms are valid, but not to the extent that we can go, we can conclude that the law is bad in itself. I think, and we can again come back to that. Do we need ex-ante regulation for digital platforms? That's a separate question, which I hope we can take. But I think if we do decide that we need this kind of regulation, then we need to think of institutional capacity, and we need to think very much, very, very carefully of who's included. By that, I think we will determine whether we are stifling innovation or just curbing anti-competitive behavior. I don't think the bill as it's framed or the report that accompanies is doing that extremely well at this point.
Absolutely.
Yeah, thank you so much for identifying those three issues, especially on the issue of judicial capacity, which many countries rarely consider. And at the end of it, when these complaints start going to the court, we'll need judges who are really conversant with the topic, especially in developing countries where we know that competition awareness is very low and limited. So back to Manju. As Dr. Darr said about institutional capacity, judicial capacity, and whether we need ex-ante regulation, there's this question about the goals of competition law in regulating digital markets. And for the EU, we know it's about fairness and contestability, in which fairness is a very subjective notion. And for India, I've seen an additional goal of transparency. Do you think that these goals are achievable if the bill was to be passed into an act?
So, Vela, that's a great question. But, as someone that's worked with the government for the past 5 years in terms of advising them, something that becomes very important here to ask is not that whether this goal is important to pursue, but also an additional question of at what cost are we willing to pursue this goal? And, that's a crucial question that I'm not sure the opportunity cost of, and, as Dr. Darr also said, the opportunity cost of, enforcing the law in its current form has been analyzed, because if we make a quick comparison to the kind of reports or the kind of studies that were done elsewhere that sort of supported a legislative framework, or an ex-ante framework, like take the platform services inquiries that are happening in Australia, or the Furman Committee report, or the EU's report on ex-ante law, etc. I think there was a clear demarcation of, or there was a clear idea in terms of who we were going after, and that also necessarily meant a clarity on who we are definitely not going after. Now, there is a twofold problem here. One, as Amber said, we have not really carried out a market study to really understand who is really competing with the likes of Amazons or Googles, and what markets are they really competing with, and are they competing with an Amazon or a Google or a Facebook for that matter? And that's one part of the problem. And second, a direct import of a lot of EU's thresholds also means that we're comparing the EU's economy to Indian economy, which is honestly a comparison of apples to oranges. Just to give you an example of the kind of competition that there is in India, and this is not to say that Indian digital markets are not concentrated, but I'm trying to here bring out a difference in degrees to which they are perhaps concentrated in the way they differ from EU versus India. So for an Amazon, you have a direct competition with by Flipkart, and right now quick commerce is also something that's very, very quickly catching speed in India. You have Blinkit that offers a 10-minute delivery, and that's giving Amazon a very, very strong competition. For every when you look at the food delivery market too, you have you have a Swiggy, you have a Zomato that is sort of competing head to head with one another. But maybe Uber Eats is one of the only few platforms that works elsewhere in the world when it comes to food delivery. When you even perhaps look at ride sharing services, for an for an Uber, you have a very well developed Ola or a Nammayatri that's built on India's digital stack that is, giving it a very good competition, or a Rapido for that matter. So I think what I'm trying to highlight here is that, yes, these are a handful of players that I'm sort of pointing out, but at the end of the day, this means that going after the big ones, the big players in these markets will have opportunity cost in terms of going after perhaps the not so big ones also, because these thresholds are not customized to, meet Indian thresholds, but are direct imports of, what's happening under the DMA. And this is for me somewhere, a little unsettling, because when you look at the larger policy goals that India has, tech is a huge bright spot for us. Ensuring that we usher innovation in India's digital ecosystem is a foremost priority. One, to propel growth. Second, to ensure job creation, and third, just in terms of the way service delivery in India happens. I mean, maybe our infrastructure when it comes to physical infrastructure is not that great, but our digital infrastructure is something to be extremely proud of. So we have a country full of digital, comparatively digital savvy, people that are largely not dependent, but maybe, are using these platforms, maybe not one of them, but a lot of them for very different purposes. So what does this mean for the consumer base at a whole? It's not a question that we've tried to answer. And, as maybe I sort of jumped into the question a little too early, Vela, but I think an interesting spin-off to the question that you asked me is that, are the goals of Indian digital competition as espoused in the draft digital competition bill ones that we want to pursue? I'd like to take a step back, and I would love to hear Amber's thoughts also on this, is that I don't think we have thought through what India's digital competition goals really are. If I were to rank them in an order of priority, what comes first? Does innovation come first, or does contestability come first? Because these are, the politics here is not divorced from economics at all. And these are, political economy questions that each country has to answer for itself. And I'm not sure that thinking has happened in India so far. And I completely agree that the draft digital competition bill does not give us any, or even the draft digital, or even the CDCL report for that matter, does not give us any clarity on, if we were looking at the goals of Indian antitrust law, how would we rank them? And that is for me somewhere, some thinking that ought to be done before we jump into enforcement, and having some clarity in terms of what is it that we're going after, especially because, and I'm here taking it as a given that India's state capacity is one that does not allow us to go after multiple goals simultaneously. So it's very important that we have a strict set of goals that we're chasing. So what are these goals in Indian digital economy is not something that India has really answered for itself. So, and I'd like to see more debate on that, so that by the time we are in a parliamentary process around the draft digital competition bill, hopefully we have a lot of this figured out. And, just sort of ping-ponging on what Amber said about institutional capacity, if we look at the market studies that the CCI has, done in the past, we see that there is only one study on e-commerce, market study on e-commerce that's been done, one on telecom. But in terms of digital markets, I think e-commerce is the only one that's covered. But if you look at the list of core digital services that we're trying to cover under the draft digital competition bill, it is so wide that I can even read, a broadband provider into it, because it's very expansive. So I don't suppose we know exactly who we are going after. This means that we might go after those that we don't want to go after, and the opportunity cost, I think, for the Indian economy is too dear and too costly here. So I'd like for all of us to pause and really think, who do we really want to go after? And I'd just like to stop there and maybe move on to Amber.
Thank you so much, Manju. And you've really raised a pertinent question on what are the goals of competition law in the digital market ecosystem. Because from an African perspective, from the market inquiry that the Competition Commission of South Africa did, and after analyzing it on the online intermediation platform, I would think about inclusivity, participation, especially for the small startups who would like to participate and compete against big tech companies. Not only against big tech companies, and also they want to compete on access to the markets. Because in some sectors like hotel and accommodation, you find the international chains are able to pay for the advertisement or the visibility to appear on Booking.com, unlike other small restaurants who do not have that capital muscle. So you cannot talk about fairness when accessing the market itself is a problem. So Amber, I would like you to comment on it, on the question of goals or competition law, because you previously mentioned the issue of having a good market analysis before we even adopt any competition law in digital markets. But then in addition to contributing to what Manju has talked about, I'd also like you to talk about the issue of remedies, whether the digital competition bill is able to address the question of appropriate remedies if any infringement occurs.
So great questions. I'm going to try and approach them slightly obliquely, because I think that I'm happily placed as a sort of on the boundary of an insider and an outsider, Manju, so I can take a bit broader view. I agree that the CDCL doesn't seem to be sure about what goals it's promoting for the digital economy. I'm not going to expand this to talk about the goals of competition enforcement, which I'm going to leave on the side for the moment. But I think even towards the digital economy, the goals are not clear, because it keeps saying we want to improve contestability and encourage innovation, but not sure how it does that. Reading the Act section by section gives me a very unsettling picture, which is that the government just wants to keep a greater control over what happens in the digital economy. Now, whenever that happens, and I've seen it happen across South Asia, I've seen it happen in Pakistan when the Competition Act was enacted back in 2007, whenever the government keeps control, it actually sort of allows itself a pass on the issue of worrying about goals, because it feels that it can take decisions as and when they arise. So there are lots of spaces in which the government has kept itself, given itself rather space to intervene in digital enforcement. The most obvious one is in exemptions. So what it can do is it can simply exempt digital enterprises from the application of the Act. And there are various criteria. There are three different conditions provided, but one of them which caught my eye was public interest. Public interest is as big as any, it's as wide as we want to define it as, right? So that's a huge caveat. Then even in terms of, there's another caveat. It says it can supersede the enforcement authority if it feels that the enforcement authority is not listening to it. It also, in terms of, it can intervene through sort of directions, I think, to the CCI. It can intervene in who is designated as the SSDE, because it can say, even if you don't meet the qualitative and quantitative criteria, there are other factors such as cybersecurity. I am absolutely clueless to understand how a competition authority can enforce issues relating to cybersecurity, which involve taking into consideration the Information Technology Act of 2000. So what it's doing is it's actually not thinking about goals at all. It's really just creating an umbrella. I would say it's creating an oversight, a very costly oversight, I might add, but at what it's really doing is creating an oversight legislation which keeps a sort of an eye out for what is happening in the digital sector. And the minute it becomes too big, the government gives itself a big role to play in how they do business. Now, we can talk about the political problems that might arise from that, but I think the economic problem that arises from that is that it distorts the level playing field. So all this idea of creating contestability is gone out of the window. I'll give you an interesting example also from the Indian context, which I came across and saved. So you'll bear with me if this was in May 2024, where I read a news item which says India to again delay caps on UPI payments market. Now, this is a very interesting headline, and I'll just expand on that for a moment, because there are several companies that manage digital payments in India. Amongst them, the largest is Google Pay. Now, Google Pay, we also know, could easily be an not Google Pay, but Google could easily be an SSDE if this bill was made into an act. And certainly Google Pay, if it's a separate company, would be an associated digital enterprise under the Act as well, right? And Manju can correct me if I've misunderstood something about the Act. Now, because India has a national goal to encourage digital payments, it is not limiting the size of the digital payment companies because it wants to encourage digital payments. And if it imposes the 30% restriction on size, then it doesn't achieve that goal. Now, that goal of encouraging digital payment and therefore letting these companies become as big as they need to be to foster that growth in digital payments, it's actually just eating into the goals of the Digital Competition Bill. And this is obviously a hypothetical example at this stage because the Digital Competition Bill is not an act yet. But there is an act which covers the market capitalization for payment companies, and even that's not being enforced. So my worry is that not only has the government created an oversight board, would end up creating what looks like CCI operating as an oversight board, it will also give itself the power to intervene as and when it deems necessary. Now, if it intervenes, for instance, in the Google case, it will probably say it's in the national interest so that Google Pay is not categorized as an SSDE or an ADE under the competition bill. The minute you take Google out, you take a lot of the associated companies out, what are you doing for the level playing field? So I think there is, we worry about goals when we have clarity and we have achieved, again, this becomes a political economy point. India has, to me, it seems that sitting on that brink of the insider-outsider perch that I enjoy quite a bit, it seems that it has national goals which it considers much more pressing, perhaps rightly so, than contestability in digital markets. So I think we are going to, if this bill is enacted, we're going to see a lot of these issues militating with each other. And as I keep saying that, it's my biggest worry is that unwarranted forgive me for using the word interference, because I think that is what it will amount to. But interference on a range of different factors like cybersecurity, national interest, going into competition law is actually, or even ex-ante regulation is actually just going to distort the level playing field that we hope that this law would create, right? Yeah. So I'm just going to stop at that. Sorry, I don't answer any of your questions very directly. You did ask me about remedies. Yeah. And I just want to quickly say that, to me, the remedies are actually less important than the process. And I think the process is so damaging, if I can again use a strong word here, it is so damaging. For instance, you're going to, let's say you've been identified as an SSDE. The earliest you can challenge that for it to be revoked is 1 year. 1 year in a life of it, it's a dog's life, right? We measure the life of digital companies in dog years because it's a very long time. 1 year in the life of a digital company is a very, very long time. It may not be such a long time in the life of a brick and mortar company. 1 year is a very long time. You've probably damaged a lot of contestability before you can even think about revoking. If the company doesn't comply and you set off fines, which are of a very high turnover, you're really hurting business. And what if you've made a mistake? Because the factors on which you can actually go after these companies are so wide-ranging. So sorry, just coming back to when you can be made into an SSDE, there's some qualitative criteria which are clearly spelled out. You have to have turnover, India this much, I don't remember the actual numbers, global turnover this much, user base in India this much, global user base, whatever. But if you don't meet those criteria, then actually we can consider many other things. And which it doesn't say all of those things, it says some of those things, which includes quite sort of wide-ranging things such as countervailing buyer power, for instance. So how are we going to decide which should apply in which market, which is more important in which market, right? It's all a bit ad hoc. So having said that, the process is so damaging that the remedies come way too late almost. I mean, the fine is the least of, Google can pretty much afford its fines. Even globally, we see Google can afford its fines because it doesn't really prevent it from doing whatever it wants to do. So I think the fines, the remedies are important, yes, but they're not as important as the very, I would say, damaging process through which this whole SSDE, and I'm just skimming the surface of it. We could have just a full conversation on designating SSDs, which I think is just has to be done so carefully, because anything you do distorts the market for a very long time.
Yeah, it seems, Manju, you really want to comment. But before you comment, Fola, do you have a question?
Hi, yes, I do. One second.
Yeah.
Okay. Hi, everyone.
Hello.
So I had a question. So, I mean, first of all, I just want to say it's really nice to have, a lot of insight from different parts of the world that are also considering these same issues about big tech and the digital economy. Because a lot of the time when I'm thinking about African issues, it's one thing, of course, to learn from what's going on in Europe, but at the same time, it's even more insightful to learn from another developing country that's navigating very similar issues in the same way. And so I've done a bit of thinking about the African protocol on competition law and the provisions that relate to the digital economy in particular. And I'll post a short blog post I wrote about it in the chat, so if anyone wants to say a bit more about that. But one of the things that I focused on was the fact that, and Amber mentioned capacity, the lack of capacity in the judicial sense, institutional sense. And I think another thing that we need to think more about is the fact that there's limited case law to use to interpret some of the terms that we're talking about in the digital economy. So the African protocol talks about self-preferencing, it talks about gatekeepers and core platform services. But in the EU, you have cases that relate to self-preferencing, like Google Shopping, for example. And so they have that sort of, should I say, institutional memory that they can use to interpret some of these terms. But we haven't got that in an African context. And I guess my question is, are there similar cases in India? I know that the WhatsApp investigation that happened that influenced what happened in Nigeria relatively recently as well. And have those cases also come to frame how the Indian ex ante regulation is going to be applied as well?
I can probably take that question. So what we see happening in all South Asian jurisdictions, but I think the two we talk about the most are India and Pakistan, but definitely what we see happening in India is some of the key terms are actually just adopted and explained with reference to the EU and quite often US. I think what India is now doing is it's expanding its scope of where it looks to for models. But I think a practice is a practice. So I think self-preferencing will be self-preferencing wherever it takes place, and will be defined very much according to how the Google Shopping case talks about self-preferencing. So in that sense, I think the conversation about capacity and institutional pathways becomes more relevant than, say, case law, because case law is the core principles are actually just recycled, if that's a good, or I should say adapted and applied. Maybe that's a better way of putting it. But I don't think they're adapted too much. They are applied because digital technology is treated like a scientific phenomena, which it is to some extent, and self-preferencing looks exactly the same, whether you observe it in India or you observe it in EU, because Google is doing it globally. So I don't think though that's the kind of case law that we need. Having said that, the report itself doesn't actually consider any of the enforcement decisions that the Competition Commission has issued over the past couple of, there have been a few. And I think to me, this was, again, something I would have liked to see in the report was a very active consideration of the decisions and identifying the practices that have been most sort of difficult to in the Indian context, but the report doesn't do that. So I hope that kind of answers your question.
Yeah, it does. Thank you very much.
And just to sort of add to what Amber is saying, a couple of things on case laws, informing the draft digital competition bill. Amber, and I'd love for you to come in here as well. There are two more aspects to this. One, the Competition Commission's decision in terms of penalizing, an entity really doesn't mean much, because these cases are litigated all the way up to the Supreme Court. So if you look at the number of cases in which the CCI has been able to recover, penalties, it's been a handful. So what does this really say? I mean, this somewhere talks about the positioning of regulators vis-a-vis, judiciary in India, and how long simply cases take to decide, and it informs us of both ways. And that one, we can't wait for cases to decide our, sort of shape our laws entirely, because in India it's too long a process. And even if you look at the handful of cases that have come before the CCI, to me, what's really strange is the cases that we've seen at the CCI level have largely been in the Android market, in the app market, largely with web search, with food, but that there was no Section 27, or there was no final decision on that. There was one on e-commerce, and one on hotel booking. So to me, what is surprising is that even if we were to look at the case laws informing our approach in the draft digital competition bill, then we would have perhaps only looked at markets where there was evidence of concentration firsthand, specifically in cases where that the CCI has investigated. But what really worries me is that we've opened up the list of core digital services to include things that the CCI has never even investigated once. So coming out with regulations there will be a Herculean task. And we've also not allowed sequencing in a way where the reason the list of core digital services is scheduled is because the central government has the power to amend the schedules to add and delete services at appropriate points in time. Now, given that we already have this flexibility, it's a little unsettling to see that we have services that the CCI has not looked into in the past that are already covered under the list of core digital services. So just to add two bits to that, I would have loved to see some case laws influencing the way the digital competition bill has drawn up, but I don't think it does it to the extent that we wanted to at this point in time.
Thank you very much. That's really helpful. Thanks.
Okay, thank you so much. It seems like time is running and the discussion is very interesting. So from the discussion we've had, some of the things I've been able to capture is that the goals should be internally driven, and then we should avoid cases of having a regulatory capture when it comes to process of designating which business firms are going to be captured by these regulations in digital markets. So to all our speakers, I would like to know, what are the lessons for Africa? What should we write from the India's experience so far as we seek to adopt our own regulation?
Manju, do you want to have a first go, or do you want me to?
I'd love to go after you, Amber. Please take it.
Make it difficult for me. Make it. So when I was thinking about Africa, Vala, because that was really the sort of overarching question I had before me, I also wanted to, I went back and read the report, which I'd read earlier. And I think I have to say, despite all the problems, I was very impressed that India was putting itself out and thinking about the digital economy as a front runner, rather than just waiting to see what all the other countries were doing. However, a lot of other countries that it mentions, most notably Korea, which is mentioned in the report, is also contemplating such a legislation, has since pulled back.
Yeah.
And in fact, what we also know is more recently, the Philippines has also pulled back. Now, this pulling back is very interesting. And I think it's in that going forward and pulling back, I think, is where the lessons are for Africa, right? And I think also the lessons for Africa, just to repeat what I've said earlier, are going to be, should be ideally driven by capacity. Goals, I think, unlike India, I would want Africa to really think about goals, think about digital penetration in real terms rather than in abstracted terms, which I think the Indian report is more abstract rather than specific in this regard. And I think really the question then, which is behind this conversation, which underlying this conversation has been, do we actually need ex-ante regulation, or should we be comfortable with sticking with what we have, which is ex post facto? And I think that what Korea has done is it's included a lot of, it's expanded its ex post facto regime to allow it to do things which can prevent, which like issuing interim orders, for instance, which can actually prevent a lot of. So I think that is something for Africa to think about and really think about where it locates itself on the spectrum of innovation and contestability. So if I were to be very simplistic, I would say, if you are more interested in focusing on startups, then don't increase the regulatory burden for startups. Because what this kind of law does, even though it looks at gatekeepers, it makes everybody incur a cost in trying to figure out, well, how far can we go? And because they don't want to be don't want to be falling foul of the CCI, because like I mentioned earlier in my conversation, the fallout of going against the CCI is very, very damaging, right? Once you are an SSDE, you've had it.
Yeah.
So it's not a good place to be in if you are a startup that wants to grow. If, however, you're a region which is at the moment the most sort of the largest platforms are the foreign platforms, which are currently stifling innovation in the context, then I think, yes, you do need a law that contains the power of those platforms, right? I don't think India is in that position, but Africa might be. So I think those are real-time considerations. Those are actual, we need to have market studies. I would say the most important thing is market studies before we have a law, and then think about what kind of a law you need. So I'm going to stop with that because I also saw a hand and then it disappeared. I think Karan, maybe you had a question, but maybe he doesn't want to ask it anymore. But Manju, do you want to go ahead? Yeah.
So just a couple of things to add on to what, sorry, is Karan speaking or?
No, I think go
Maybe
ahead.
we can let him speak.
Yeah.
Is Karan
Oh,
speaking?
he says he's waiting.
Oh, he wants to wait. Fine.
So Manju, you can speak.
Okay. So
Yeah.
I've just put two very interesting papers. I think that's sort of shaped a lot of how I'm looking at the way India is, approaching digital competition in the chat box. One is on premature imitation, that a lot of countries tend to do in terms of, like, there are, of course, best practices that are emerging in everywhere, especially, when we look to the EU and UK as traditionally looked at them as countries with the best sort of regulatory practices. One thing that we need to be sure if those are best practices, because there is also best capacity that is supplementing it, and largely to what Amber is saying. So, it might in fact be more damaging than not intervening if we intervened poorly. And I suppose that is what Africa needs to keep in mind when it is thinking about digital market, sort of regulation. Second, there are a lot of reasons why, because a lot of our laws suffer from a colonial hangover in India. There is a reason why, the cost of doing business in India is not very cheap, in that, our labor markets are also pretty stringent in the way we operate, et cetera, which means that Indian firms find it hard as it is to scale. So there's also another paper that I've sort of posted here, which is about why Indian firms don't scale, which talks about how, there are a lot of labor laws that apply in India right after you hit from 9 workers to 10 workers. And if I were to put a number to that, it means that the cost of doing business from when you look at a 9-worker organization to a 10-worker organization means that the cost of your business goes up by 35%. And this is simply the cost of compliance. So, we have to really ask ourselves that question in terms of, do we really want to, where do we really want to hit the hammer, really? Do we want to disincentivize companies or firms from getting big in the first place at all? Because the way the SSD thresholds are framed, and as Amber rightly pointed out, by the time this bill becomes a law, I think there will be a lot more players that are going to get, subsumed under the thresholds that we already have. So what does this really mean in terms of ensuring that the law is also able to adequately respond to the dynamism of digital markets? And I'm not sure, we know answers to that yet, really. So I suppose that's another part of it, in that when we are going to regulate digital markets, and I think Africa could also keep this as a lesson to learn from India, perhaps, that dynamism is going to be a very crucial part of digital markets regulation as a whole. And let's only only attempt it if our capacity allows for that dynamism to, exist in the first place. And also in terms of what does this really mean for firms that are looking to scale, really? That's the second order question. And the last question that I suppose I want to leave this question here with, this response here with, is generally in terms of, let's have the problem statement clear before we sort of intervene, because there are a lot of places, there are maybe a handful of places in the digital economy where an ex-ante regulation may be better suited, right? But that may be a very, very narrow size of the pie than the size of the pie that we're currently looking at. Maybe, P2B relationships, that is, platform to business relationships, is one place where there is generally a lot of asymmetry in bargaining power, etc. And EU has tried to do something through P2B regulations. Maybe that's an additional model that India could consider, that is also regulatorily a lot less costly, and something that can be subsumed within existing regimes, as opposed to trying to build capacity from scratch and trying to build out a new and an oversight board of sorts, as as Amber was clearly talking about, because this essentially changes the way the CCI functions in and of itself, and I'm not sure we're sort of ready for that as of yet. So I think that is also an important lesson that Africa could sort of keep in mind, in terms of, let us only respond to those problems that we have to respond with first, and slowly learn along the way in terms of how to respond to dynamic markets as we sort of go ahead, as opposed to trying to get our fingers everywhere and causing a lot of regulatory uncertainties for firms that are actually looking to scale and can be very, very promising for India's GDP and economic growth as a whole. So yeah, that's where I'd like to sort of leave this response.
Can I just quickly, Dean, I want to just flag something that Manju had raised earlier, which I thought was so important. Manju, you said that you had simply, not you personally, but the report had simply transplanted the enforcement infrastructure from the competition bill to the DCB. And I want to link this to your point about dynamism, because I think you can't have dynamic markets if you have this kind of stringent enforcement procedures. I mean, this is, and there I think the DMCC, the UK bill is actually more interesting, because they talk about market studies, and they talk about the softer option of going and speaking to, and and there is a learning process, because they'll be engaging with companies, the SMEs that are engaged in digital activity, and really working out with them what might be a better solution than hitting them with a hammer, I think, which is what this does. And I think it again goes back to the capacity point, that you're creating this infrastructure and these remedies and these stringent sort of punishments, but actually, do you have the capacity to enforce it? And I think we don't have that level of for instance, in the UK spent several years building the DMU capacity in the digital markets unit before it even established the digital markets unit of the CMA. It was established only this year. So long before the law was enacted, which was just this year, it had spent years working on the DMU. So I think unless we have, I would say the law is the least important bit of the puzzle. There are a lot more important things that need to go into it. But I just stopped there. Sorry, just wanted to.
Oh, I think it's becoming so interesting, and time is not on side. Let's have a question before I ask the final question.
Yeah, is it the right time?
Karan, yeah.
Okay, perfect. Thank you so much for allowing me to ask it. I hope it's okay if I do that with my screen off. I won't make this more of a comment than a question, but I'll just quickly set a little context for my worry. While I'm new to the competition market, my worry about the competition market, right? And that's that not only is state capacity low in India generally, but I think the worry is that in competition market, if you look at sort of the Pritchett-Woolcock framework of 4 cases where it's difficult to achieve capacity, not only is it low now, it might be in the future, which is the number of transactions. Like Manjushree spoke, before that, it's always a delight to hear from Manjushree and Amber, so I think I should set context there. As Manjushree spoke, you could have varied examples, right? Telecom being one of the ones she gave. You have discretion. Amber spoke about how Google Pay there's discretion within CCI, which sort of, and public interest, which is sort of keeping Google Pay safe. I don't think I have to speak about how important the stakes are here. So sort of out of 4 which have come out of Pritchett and Woolcock, 3 cases where it's difficult to achieve state capacity exist within the domain of competition markets. And then my question becomes that when you give power to state agencies before you give them state capacity, you're not really giving this power to agencies, but rather the personnel of the agency, which sort of makes it even harder in the future to achieve state capacity because these personnel will resist it. Is there an example which hopefully Africa and even India can learn from in competition markets where these powers are dispersed, right? So for example, the power to penalize sitting within the CCI versus does it sit out in a different body or agency, such as the compact hoped to do in India? Similarly, the power to legislate some of it sitting outside the CCI, hopefully in parliament on principal issues. So is there a way to think about your executive, legislature, and judicial capacities not being focused in the competition market within a state agency or regulator?
That's a really, sorry, well, I'm just quickly going to come in and say that's a really interesting question. And it makes me think about, there are umpteen models of competition authorities and competition enforcement. The reason why the EU model has been so successfully transplanted around the globe is because precisely because it's the opposite of dispersed, because it's self-contained and it's easier to know where to target your interventions or where to target capacity building. So I think it's, again, like with most other things, it's a trade-off. I mean, if you disperse it, you might not even achieve as much as you're hoping to achieve if it is in one place. But yeah, I mean, I think in terms of models, there are many. I mean, most obviously there is the US model, which is very different, right? But will it work in developing countries which already have sort of as I think both Manju and Vala have said, they don't really get competition. They're not really interested in competition. So unless we create a body that is an expert body that recognizes its role and becomes an advocate for its role as well. But again, yeah, Manju, do you have something to add to that? Because I just felt this was.
Yeah, just a couple of things here. I mean, that's a very good question generally in terms of separation of powers, but I think this goes back to, I think how Indian regulatory architecture generally in Indian regulators are sort of thought through. And this was in fact a question that the Competition Law Review Committee had considered, in that, there are very different models when we look at competition enforcement. There's the bifurcated judicial model, the unitary expert model, and the bifurcated expert model as well. And these are, many different countries have different ways of doing it. Australia has a judicial model, so does Jamaica. I think EU has an integrated model in which we largely take support from, or reference from. But changing around, hypothetically, that's a great question, in that can we separate these powers really? But I'm not sure that is a question that we can answer with only the competition regulator as an example. This will necessarily mean that we will have to look at the way other regulators in India, including SEBI and IBBI, sort of work, because SEBI, one of the most mature regulators, market regulators in India, is the securities regulator. It has a very similar model. And in fact, for everything that the CCI's law does, usually the SEBI's law is quoted as an example of SEBI is allowed to do this, why is the CCI not allowed to? So, this sort of hits at the heart of how Indian regulatory architecture itself is designed. And unfortunately, I think this is a little bit like, having a building built from scratch. Once you put in the columns in place, there is only so much flexibility you're allowed to have after a point in time. And I think the columns have advocated for an integrated model at this point in time. And I'm not sure if there is looking back that's allowed for us at this point in time, unless something changes our minds entirely about this. I am not sure if a look back only for competition to see if we can, bifurcate these functions is possible, because it's going to open a can of worms in terms of how we imagine regulatory bodies in India altogether. So, yeah.
Well, thank you so much. We don't have time on our side, so we'll just ask the last question, and you can take 2 minutes each to answer. So the first question is, if we recommend the wait-and-see approach for developing countries, don't you think that the big tech companies operating in this market, because they operate in this market and they're dominant in this market, will take advantage of the unregulated framework and engage in exploitative practices that will even hinder the startups to emerge and participate in the market? And secondly, there's an important issue that has been raised by various practitioners on the issue of geopolitics of digital market regulation. From some of the articles I've read, there's been an argument that if India strictly regulates US big tech companies, it's going to constrain its relationship with the US. And it seems like the US favors India as an opportunity to compete against China. So how can we also handle the geopolitics? So the question is the limited regulatory framework and also the issue of addressing the geopolitics. Yeah. Anyone can start.
Amber, do you want to go first, as always?
As always, no, not as always, but I'll venture.
Yeah.
I think the wait and see approach, you cannot only wait and see. I think something needs to be done. I think the question is what needs to be done, and we've tried to suggest a few things. One of the things that was coming to mind when I was thinking about this seminar today was that dominant enterprises have special responsibility, even under ex post facto.
Yeah.
I think that is such a good opportunity for us, for developing countries, to actually very easily expand what they are able to do even under existing ex post facto legislation, which is, I think, many countries have. We know over 130 jurisdictions have these laws. So obviously, majority of them are developing countries. So I think under the special responsibility, a lot of what we are asking digital enterprises to refrain from, the interoperability point, for instance, or data gathering, I think that or self-preferencing, I think a lot of that can actually go into an expanded special responsibility understanding with some sort of interim order regime that will allow a competition authority to intervene before things get out of hand. It is less than a full-fledged legal regime governing digital enterprise, as India has tried to do. But I think when I look at the Korean example, I feel they're going a little bit in the direction of, okay, let's keep a lookout. Again, I don't read Korean, so I'm limited to reading what other people have written about it. But I think I wouldn't say wait and see. I absolutely agree. We don't want these things to become a bigger problem, waiting and then try to work with ex post facto enforcement. But I think there is room in the existing legislation, and the principle of special responsibility gives us very big space in which to enter. The second point, the geopolitics, I mean, when you mentioned it, I was just totally smiling because I thought that actually dictates a lot of what we do in developing countries. I mean, much more than any economic consideration, much more than contestability, transparency, much more than even our human rights and well-being of our people. The geopolitics is a huge factor. And again, I'll just say that the Indian regime has kept that opportunity for itself, that we can exempt anybody from the application of this law if it's not in the national interest, or if we're bound under some treaties. So I can see that happening. And I think that that's where we will see a lot of the geopolitical considerations coming in. Even less than geopolitical, our FDI, we love foreign direct investment. If we're sitting in the developed global south, or as we now refer to it as the global majority countries, we think that if we have foreign direct investment, it will solve all our problems. Now, that's a separate point, whether it will or it won't, but that is how we think. And will we really turn away Amazon because we're going to be so strict on them? Or are we going to say, Google, please go away, and not let India become a rising, the next star in Google or Amazon? So yeah, I think, absolutely, we'll see geopolitics coming in. I think that's why the government has kept the caveat for itself. But even less than geopolitics, we will see our investment interests coming into play in how we go after these. So I see this law more as a white elephant, if it's ever enacted. And my biggest worry is it will be used to go after people that we don't like, and which will actually mean we will actually let the big players go free. But that's my worry. I mean, we're nowhere near that happening. That's always a worry.
Just to quickly come to the same questions, and of course, I agree with a lot of things that Amber just said, and just to quickly add on to things there on wait and see, right? So that I don't think that's a legal question entirely. That's really an economics question, and I think that really depends on how pressing is really the concern in digital markets at this point in time, and are your existing tools in a way where you cannot just bend them around, or are they so immalleable that you cannot use them to intervene? Because one of the things that really stands out to me is that given that the enforcement procedure under the digital competition bill is similar, an interim order I don't think would have worked any differently from what the digital competition bill would anticipates. And if you look at the number of companies that may be self-notifying to the CCI, sorting through how many of those to be filtered out as SSDAs and how many don't itself is going to be a huge process for a 3-member committee in the CCI, like a 3-member commission at the CCI. So I think the question of wait and watch, I don't think can be independently answered. If we are doing something about it, we should be sure to do it only where there is a problem, because I completely agree that there is that there is a lot of smoke, so there must be a fire somewhere. So, but we have to, sort of try and really spot the fire as opposed to, trying to burn down the whole forest. I'm just a little scared that we might be veering a little too close to that. Sorry, your second question, Vella, was with respect to
the geopolitics.
The geopolitics, yes. That's a very interesting question, because India is trying to promote its own UPI, etc. Everywhere else in the world. So it's not like we don't have our own digital agendas, and one that perhaps is potentially competition to how a Google operates, or potentially how an Amazon Web Service in fact operates, because I see the way we are building India Stack as a direct competition to that. I mean, Nammayatri in India, which is a cab local auto hailing app, is in fact now more popular in certain parts of India than an Uber or an Ola is, because this allows you to directly, bargain with a driver, give them a tip to arrive faster, etc., etc. So the level of market distortion is much lower than the kind of the way it would be if you supported intermediation in the way Uber and Ola sort of do it. So yes, we have our own agendas to push, but I think the geopolitics question is far more interesting here. And Amber, correct me if I'm wrong, because of how big a bright spot GCCs for us are, global capability centers, are where we are trying to, focus Indian economy in terms of exporting services. Services is largely looking at, and if you have a situation where, for Google Shopping's fault, if you can drag Google's backend services into the penalty calculation, somewhere that is worrisome to me in terms of, and Australia really fought it out with Google to ensure that the bargaining code is something that they're okay with, but I'm not sure the advertisement, the new advertisement laws was something that, Google was complying with. I'm really not sure whether India will want to take such a tough fight to someone like Google, especially because I think, Vella, you pointed this out initially in your question, can we really compare access to, fairness? Because that's a very, very crucial question. In a lot of remote parts of India, especially during COVID, communication was possible because we had something like a YouTube or a Google or a WhatsApp. I mean, really, can we compare the kind of last mile delivery that a lot of these big tech companies have provided us with, compare that to the fact that there is no contestability as a reason to take a big fight to them? I'm not really sure. And I do agree with Amber that, a lot of this will feed into how this law really takes shape. And it is really interesting because I do hope all of these somewhat, opposing forces really push the bill into some sort of an equilibrium at a place where it can truly be enforceable in the spirit that it intends to be. But right now, there is a lot of room for discussion and discourse around this. And I hope that the bill becomes a much better version than it is currently. So yes, it's great that we're all talking about this, but many, many more, I think, kilometers to run before, we call it a day on digital competition.
Oh, thank you so much, Manju and Amber, for this discussion. I was checking if anyone is leaving and nobody was leaving. So this means that this was a very interesting topic that we'll still continue having conversations on this topic as the regulation of digital markets continues developing. So I want to say thank you so much for everyone who took time to join, and also to ask you to follow us on YouTube channel. I'm going to upload this recording on YouTube so that you can listen to it every time you want to. You can share, and even the future generation is going to listen to it. And also in October, we are going to have a series of events. We are going to have a US expert who has been very critical on regulation of US big tech companies using competition law. We'll have an expert from Korea, Japan, and also from Nigeria. So don't miss the events that are coming. And again, thank you so much. And we've come to an end of this session.
Thank you. Thank you very much.
Thank you very much for all your time, and it's always a pleasure.